you. Hi, everyone. Sorry for the delay for those of you waiting. And then I think some people are hopping over from the last session. So we're going to give a couple minutes for everyone to get settled into our next topic. The last one was great. If you didn't check it out, we're going to have links for you to be able to watch the recording. I think it's going to be really helpful if you're able to check out the previous ones. The student loan toolbox and team has really set this up to be kind of, you start in the beginning with the ABCs here of the student loans, and then we're getting really down to the very practical, granular, useful stuff. So you kind of build that foundation and get into the really practical. So I'd really recommend taking a chance to take a look at the other ones if you weren't able to. And then as people roll in here, we're going to go ahead and get started on our next topic. So all good stuff. It means we have such good information, great questions that we're having, and good conversation. So I do hope that everyone is finding this helpful. It really feels like people are getting a lot out of these, which is very exciting. So today, in this last and final session from our Student Loan Bankruptcy Symposium, we're going to be taking a look here at this unique once-in-a-lifetime offer from Department of Education. So to get defaulted federal loans fixed with a 5-minute call and to really get those loans back on track quickly. So my name is Mandy Ballinger. I'm the Vice President of Next Chapter, and we are partnered with Student Loan Toolbox, and Josh is going to be doing your presentation here today. And we're going to go through the slides here, but I did want to give just a quick notes for housekeeping. As I mentioned, all of these sessions are being recorded. We send an email, we'll send one at the end of the day with the presentation so that you have a PDF copy of those to reference, and then also links to the recordings as well, so you can rewatch any of this wonderful information. And then we're also going to include a link to pre-register for Bankruptcy Week. We will be hosting this in a definitive, we haven't quite figured out the date yet, but we are going to be hosting this webinar series similar to this with experts to help, new and maybe seasoned attorneys in the bankruptcy world with all things bankruptcy related and things like this, student loans, things that are kind of in that sphere that would be helpful for you. So be sure to register for that. We are offering a free per case in Next Chapter for your first case. If you, which you're here, you attend one of the webinars as part of the symposium, and if you register for BK Week. And then we're also going to provide a promo code that offers 10% for the Student Loan Law Workshop through Student Loan Toolbox. So they're going to be offering that for a 2023 workshop, and it is applicable to both attorney and paralegal tickets, and they also offer special pricing for groups and for legal aid. And then lastly, we're going to share a link to sign up for Next Chapter. So if you haven't already, please sign up for an account and we will help you to get started. And then last thing here is we're going to use the Q&A feature. So if you've been through these, you know the drill, ask your questions in there. When Josh is able to, he'll get to those. And if we need to answer some at the end, we'll do that as well. So that's my spiel. I'm going to hand it over to Josh to dive right back in.
Okay, hi. For those of you that are brand new, where have you been? My name is Joshua Cohen. I'm a student loan lawyer. I've been doing this since 2008. I'm a little out of breath from running through the last one, and I apologize again on the bad timing, but we're going to have time on this one. What I want this one to start out with is fresh start. Now, normally when we hear fresh start, we're thinking bankruptcy. Well, that's not what this one is. This fresh start program is being offered by the Department of Education as a fresh start for loans that are in default, federal loans, of course. All right. And this program is barely being talked about, but we should talk about it because it can really save your clients. All right. So what we're going to talk about is default and the remedies and the cures, and then I'm going to talk about the fresh start part of it. But I'm also going to have time. I'm going to throw in some other administrative discharge updates that are coming with the new regulations that were just passed. So they'll be active as of July of 2023. And I will then open the floor to almost any student loan question. I say almost because I'm an attorney and I have to have my disclaimer. All right. So let's get into default. Actually, no, let's not get into default. Let's talk about default. Okay, with federal student loans, this is very different than anything else you've encountered. Federal loans don't default until they're 270 days late, until they have missed 9 months of payments. Okay, the first that they miss and the seventh that they miss, they're not defaulted yet. That's very different than any other consumer product you've heard of. All those other ones, a car loan, a private loan, mortgage, you miss the first payment, you technically breached the contract and you've defaulted. So federal loans don't. They are delinquent until you get to that 9th month and you miss it. You can save the loan before default with a forbearance, with a deferment, or just get them on a payment plan. When you get them on an IDR, even though they're a couple of months behind, that IDR starts them at day 0. There's an unspoken forbearance that's tied to the IDR that automatically rolls them back to day 0. So they're not playing constant catch up. When they start an IDR and they're a few months behind, they start at day 0. Okay. Their credit is still going to show that they were late. There's nothing you can do to fix that. Just get them on a payment plan so they don't default. But if they default, what are they going to face? They're going to face collection calls. They're allowed collection fees of up to 25% of the balance, or 30 to 40% if it's a perfect loan. They're going to miss their tax refund because that's going to be intercepted. If they're on Social Security, including disability, they're going to miss 15% of it, although they do have to be left with $750 a month. Anything above that's going to be attached. Wage garnishments, those are the big ones that drive clients into our office. No lawsuit is required. They get a 30-day warning letter. That's it. Okay. Okay. And it's 15% of disposable pay. That's after taxes and health insurance, but that's it. It is before union dues or 401ks or anything like that. 15%. And they can sue you. Okay, there is no extra fee. Default means that you have breached the contract and then they are allowed to charge you a 25% collection fee. You can consolidate at any time. Consolidation is not triggered only by default. You can consolidate before default, maybe to stop a default. But consolidation, default is not a requirement for consolidation. Anyone who tells you that is lying. You should report them to the Department of Education. That's wrong. Lawsuits are a little scary. If it's a direct loan, your debtor gets sued by the Department of Justice and they get a lawsuit that is titled United States of America versus you. You're sued by your country. Okay. Other default consequences. You're ineligible for federal employment. If you were defaulted on a federal loan, you cannot become a federal employee. And in fact, your employment as a federal employment can sometimes be in jeopardy with federal or state licensing or security clearance. Military has a problem with this all the time. Now, don't worry about this, because as long as you're working with the client and you let the military personnel know somehow that, hey, I'm working with them, we're going to get them out of default, they're not going to lose their security clearance. But if they don't do anything, that can be an issue. They're also ineligible to partake in Medicare if they default on a HEAL loan. I've never spoken about HEAL loans. Very quickly, it is a health, education, and access loan from Health and Human Services, not from Department of Ed. But they are now being administered by Department of Ed, and they can be brought over to the Department of Ed through a consolidation, in which case they can have IDR, they can have public service loan forgiveness, they can have the IDR account adjustment I spoke about yesterday, and they can have the other things that we spoke about. However, discharge is a completely different animal. And one question we still have is, can those HEAL loans be discharged under the DOJ guidance? My answer is, I don't know. We may find out. And the worst one for your client, oh my God, the world is falling. bad credit. Ah. All right. How do we fix it? There's 3 ways to do it. One of them is through a consolidation. Okay, again, it's similar to a mortgage refinance in that you do it through a servicer, but the servicer doesn't hold the note. The note is held by the Department of Education. There are only 4 servicers now. They just 2 servicers just left the system. So we're down to 4 of them. And that's the servicer that's going to bill you. Credit is not a factor. If you have a federal loan, you're allowed to consolidate. The process takes 30 to 90 days. They're averaging about 45. You must do it through one of 4 servicers again. Let's just get rid of this. So, nope. It's 4. They just changed that on Monday. You can't do this, however, if there's a judgment in place or a wage garnishment. Now, wage garnishment doesn't mean judgment. Again, it's administrative, so they don't need to sue you. But if there's a wage garnishment, you can't do a consolidation. None of this is happening right now during the CARES Act. All right, so we know we have until at least August. You've got time. You also can't do this if the only loan you have is a direct consolidation loan. Now, don't get confused here. As I said in the last webinar, if you're looking at studentaid.gov and you see a subsidized consolidation and an unsubsidized consolidation, those are not 2 separate loans. They're one loan, and that one loan cannot be consolidated by itself. Any other loan can be consolidated by itself. Stafford, Perkins loan, even an FFEL consolidation can be reconsolidated by itself to direct loan. But if the only loan your debtor has is a direct consolidation loan and they're in default, they can't get out through consolidation. So what can they do? Well, they can try the second one, rehabilitation. It takes the word default off of their credit. Ooh, what is that worth? 5 points. 9 payments are required within 10 months. It's a 10-month plan. They've got to make 9 payments. And they're allowed to skip a payment. This is already well settled because I had this class action a decade ago. They have 10 months to make 9 payments. The payments must be reasonable and affordable. Now, it's reasonable and affordable to the debtor, not the debt collector. There's 2 offers. The first one is going to be a 15% formula, similar to IBR. It's the same formula, but don't ask for income-based repayment because you can't have it when you're in default. Okay. It's the same formula though. So if you're using Toolbox, which tells you what IBR is, boom, that's what the rehabilitation payment would be as well. If they can't afford it, probably because there's a wage garnishment, then you can ask for a financial review where they'll look at your client's necessary expenses and they can reduce the payment to as low as $5 a month. As long as your client makes those 9 $5 a month payments, they'll get out of default. You could only do this once per loan after 2008. So if they've already done it, they can't do it again. But that's per loan. So if they did it on a Stafford loan and then they default again after 08, after they've rehabilitated, they can consolidate. But if they do a direct loan consolidation and that's all they have and they default and it's already been rehabilitated, they're screwed. They're stuck. Except for now. Right now, we have a new thing. Fresh start. This is huge, it's new, and it's once in a lifetime. We're not going to see this again. This is for any federal student loan in default, but not a Perkins. It's good for FFEL, it's good for direct loan. Basically, it allows a client to enroll directly into IDR. They pick up the phone, they call either a default resolution group that services defaulted direct loans, or they can call ECMC or whoever their guarantee agency is. They pick up the phone and say, hi, I would like fresh start. And it's a 5-minute phone call. And they're enrolled directly into IDR. They ask for the client's income information over the phone without any verification. And it takes them about 30 days to process, but the phone call is 5 minutes. That's it. And within 30, 60 days, the client's loan is out of default and boom, put right into an IDR plan. Done. This is effective as of January 1st, and it's good until June 30th of 2024. Okay. There's also a credit fix I'll talk about on the next slide. It takes the default notation off of the CARES system. Now, this is the federal database of delinquent federal debtors. This will often stop a debtor from closing on a home loan, especially if it's FHA or Nellie May is involved. It will take them right off the federal database. They can get more student loans if they want them, and there is no collection activity during all of this. So there will be no wage garnishment, no Social Security offset, no federal tax refund starting until at least July of 2024. Yes, Jill, the collection fees are removed when the loan is out of default. So if you had $100,000 and you defaulted, they now say you owe $125,000, but you do the fresh start, you're back to $100,000. Not bad. Not bad. All right. Again, no collection conduct. So this is actually a downer for us, because one of the things that used to drive traffic into a bankruptcy office is a wage garnishment or losing your tax refund. That's not happening right now, and that won't happen until at least July of 2024. However, there are other reasons people are coming into your office, and they're coming in to save their house or their car. Hey, do you have a federal student loan? Do you? Okay, let's look at it. Because if we're filing anyway, what do we want to do? Do we want to get it out of default? Do we want to get into an IDR? Do we need to consolidate you? Are we going to discharge your loan through the new DOJ guidance? Wink, wink. Okay. You should be looking at all of this. Student loan toolbox helps you do. Okay. To talk about the credit fix, it deletes the trade line if it's been delinquent for more than 7 years. Now, let me clarify this. This is under the Fair Credit Reporting Act. Federal student loans are subject to the Fair Credit Reporting Act. The Department of Education is not. You can't sue them under the FCRA. But everybody else in the student loan system is. The servicers, the guarantee agencies, the collectors. Now, a federal student loan can be reported on your credit for 7.5 years from the date you miss your first payment, not the date of default. So by the time you default, it's been on your credit already for 9 months because you've missed 9 months of payment. And then after 7.5 years, it falls off your credit. You're still in default. If you're still in default for more than 7.5 years, it falls off your credit. It's not uncommon for a client to come in and say, I didn't know I owed it anymore. It's not on my credit. You still owe it. It's just not on your credit. Okay. Jeff, I'm going to answer that in a minute. So hold that question there. We're going to get to that when I'm done. Now, one of the tricks that people don't realize is with an FFEL loan, yes, it can show up for 7.5 years, but when the loan is transferred from the guarantee agency to the Department of Ed, it re-ages, and that 7.5 years restarts. So if it hasn't been on your report because it's been 10 years, it comes back on, and it stays on for 7.5 years since the Department of Education took it over. But under this, with the fresh start, they will only look at those 7 years. And if it's been more than 7 years, boom, it comes off the credit report. Okay. It changes the default loan to current, and the reporting time, this is also big, is still 7 years from the original delinquency, even if they default again after fresh start. So let's say they were in default for 4 years, they do fresh start, they don't talk to you anymore, they screw up, they default, it can only be reported for an additional 3 years, for a total of 7 years. So this is a nice thing. Okay. That's the credit report. At the end of the day, I don't think this is worth squat. What I care about is getting the loan out of default, getting them on an IDR, and getting them into a payment, getting them to, again, that IDR so that they can have forgiveness. Now, you have a choice in front of you. Do I do fresh start or do I do a consolidation? The answer is it depends. If it's an FFEL and it's not yet May 1st, I'm going to suggest you do a consolidation and bring it to direct loans. Why? Because they got to do it by May 1st to get the IDR account adjustment. If you have no idea what I'm talking about, look at yesterday's webinar about IDR recount. Okay. Fresh Start isn't a program. It's a 5-minute phone call, Betsy. And boom, they're out of default. What I will say, this is a timing question, don't file that bankruptcy until you have seen that the loan is fully out of default, that the 30 or 60 days, whatever long it takes, is out of default, because I do believe filing the bankruptcy might screw up how it works. But, so Fresh Start has two components. That's a good question, Betsy. I'm going to come back to that. So again, the question is, if they have an FFEL, I would do the consolidation before May 1st to get the IDR retained. If it's after May 1st, it's not going to make a lick of difference. I still want to bring them over to direct loans because they can have repay, which is cheaper, and they can have the new repay version 2.0, which comes out, we hope, in September. They can't have that as an FFEL. Do we care about the credit? Yeah, you can have that discussion with them. There's nothing stopping you from doing the Fresh Start and then consolidation. You can do that. Okay. Yes, Jessica, once they're out of default, they can have federal employment. So whether they consolidate out or rehabilitate out or do the Fresh Start, once they're out of default, they're eligible for federal employment and they're eligible to close on their FHA loan. Okay. Now let's talk about the problem with Fresh Start and Chapter 13. So we don't know the answer to this question. I am still talking to Department of Justice and to Department of Education. And honestly, I'm working with John Rao out of NCLC to find out the answer. Fresh Start has two components. One, pick up the phone to give them the information so that they get you out of default. And two, you're committing to an IDR payment. One of the questions I have is, will they allow you to do Fresh Start if you're in a Chapter 13? Or is Default Resolution Group going to say, I'm sorry, we can't talk to you because they feel like it's a bankruptcy stay violation? Is it a stay violation to talk to the debtor? You're not collecting money from them, but you're getting them out of default and you are signing them up for a repayment plan, which means you might be violating the stay. So one, we don't even know if the Department of Ed will talk to people that are in a 13. The second problem is your debtor is committing to an IDR plan. Now, if you're in Florida, you all have student loan programs. You are allowed to bifurcate. You're allowed under 1322B1, I believe, to have fair discrimination and to enroll them in an IDR plan. You can do this in Eastern District of Pennsylvania. You can do it in Vermont. You can do it in Southern District of New York. Other places, it's hit or miss. So if you're allowed to do IDR, you need to amend the plan to allow that IDR number. What if you're not allowed to amend the plan for IDR? Are they still allowed to do Fresh Start? Is your client allowed to lie and say, yes, I'm going to do IDR when in truth they can't do the 13? Those are big, big questions. Or are you allowed to go in and amend the plan for the IDR with your reason being, we can get them out of default, but we can only do it between now and June of 2024. If their plan is going past June of 2024, it won't be done. If the plan is going to finish before June of 2024, you don't really have the same argument because they can finish the 13 and then do the Fresh Start. But if their plan goes beyond June of 2024, will your judge, I don't care about your trustee, it's the judge's court. Will your judge allow you to amend the plan for an IDR for the purpose of getting out of default? Because this is a once-in-a-lifetime plan. The only way they're getting out of default. Will your judge say, no, I only allow consolidations, and by the way, I don't even allow that. This is all going to be touch and go. It's going to be judge by judge outside of those other places where they already allow student loan payments. I am more than happy to talk to your courts. I'm more than happy to have around a Zoom invitational with your judges and your trustees so they can explain how this works, because they only need to do it until June of 2024. But the other advantage, again, not only are you getting them out of default, you are also getting them on IDR, which means you're getting them closer to forgiveness. If you're allowed to do a consolidation before May, then you're getting them an IDR recount and they're closer to forgiveness. And they can knock out time for public service loan forgiveness for those clients that qualify. So there's all of that. The other reason you don't want payments made during default is 25% goes to the debt collector that isn't doing anything because they're in bankruptcy. So if your judge says, well, the planned payment is $500 a month and that's what I want, great, but only $400 is going towards the loan. Because 25% goes to the debt collector. Now, I might be mistaken there because it's bankruptcy, they don't do that. But under the law, they are allowed to do it. And I think this needs to be presented to your judges so that they can say, wait a minute, let's make sure it's going towards the loan. And by the way, you're not paying interest during the 13. So they'll know at the 13, they have this interest that tracks that boom, hits your client. Okay. So yeah, 13s can be a problem for Fresh Start. As soon as I know the answer, I'll publicize it. I'll let you folks know. That is Fresh Start in a nutshell. Pick up the phone, boom, done. Jeff, I don't think you can get paid for Fresh Start because your client does it. You can't do it without your client. You can't pick up and say, I have a power of attorney because there are disclaimers that need to be read directly to your client. So I don't know that you can do Fresh Start for your client. Now, if your client is in the office and they paid for your consult, which they should be paying you for a student loan consult. I'll talk about that in the workshop. We spend 2 hours on marketing and how to get paid for this. If they're in the office with you, then yeah, you pick up the phone with your client, your client's there for the disclaimers, boom, done. Took you 5 minutes. Right? How do you get paid for consolidations and analyses? Very easy. I take check, I take credit card, I take debit card, I take ACH through LawPay, and I finance my clients, so I'm not worried about it. Okay. What else do I want to talk about now since we have time? I want to talk about administrative discharge updates that are coming as of July 1st, 2020. Now, total and permanent disability discharge is something you folks are familiar with. You've heard about it, but it's becoming even easier to do, which means we may not need adversary for our disabled folks. Okay, because as of July of 2023, these are the changes. Everything is still there. The VA discharge is still there. There's no change to it, so it's not on the slide. Okay. Thank you, DJ. You can do a motion to approve IDR, take advantage of Fresh Start. I think that makes sense. You folks can contact DJ if you'd like to see what that motion looks like. All right. So changes to TPD. For Social Security disability, it used to be, right now, it's a 5-year review on their benefit period query from SSO for Social Security. As of July 1st, they've reduced it to a 3-year review period. That's much more common. You get a copy of that shows it's 3 years or more. You staple it to the application and boom, in 60 days, their loan is done. But now they've opened the door even more. If you have any kind of proof that your client has been on Social Security for 5 years, you staple that proof to the application and it's gone. It doesn't even matter if their review period was 3 or more years. If they've been on disability for 5 years or more, done. And this is even better. If your client is aged out of disability and now they're on retirement Social Security, but they were on Social Security, and you can meet either one of these, either they had a 3-year review period or they were on disability for at least 5 years, you staple that proof to the application and boom, their loan is gone. This is opening the door for so many people. So in Toolbox, if they check the box that said disability and you see it, because you're also going to see an alert that says disability, ask them these questions. Let me see your BPQI. How long were you on disability? If they can say I was on it for 5 years, or their review period is 3 or more years, as of July 1st, boom, you're going to get it discharged. You don't need an adversary. And how much do you charge for these? A lot less than an adversary. Boom, done. A disability discharge is also a tax-free, so you don't have to worry about the bankruptcy. You don't need the bankruptcy to make it tax-free. Okay, and for the doctor certifications, they've opened up who can sign it. It used to be, Samantha, this applies to Parent Plus loans too. It doesn't matter that it's a Parent Plus loan. If the parent, the borrower is disabled, this applies. If the student is disabled, that doesn't apply to a Parent Plus loan. It's got to be the borrower. So for doctor certification, it's changed. Right now, only a doctor or a DO can sign the forms. As of July 1st, it can be a nurse practitioner, it can be a physician's assistant, and it can be a psychologist. Right now, it has to be a psychiatrist. Well, what if you're not so bad that you need drugs? Then you don't have a psychiatrist, you have a psychologist. As of July 1st, a psychologist can sign off on the form. This right here is going to open the door to so many more people. TPD is going to be life-changing. And I can't believe I left this off. There's a 3-year monitoring period right now where they monitor your client for the following 3 years to make sure they don't earn more than the poverty index of family of 2. As of July 1st, that goes away permanently. It means once they get a discharge after July 1st, it's gone. It doesn't matter if they get better and go back to work. If they qualified for the discharge and they got the discharge, that's it. They're done. Woohoo! All right, let's talk about borrower defense to repayment changes as of July 1st. Okay, 1, it applies to all applications that are pending or submitted as of July 1st. It means if anybody sends in an application now, Department of Ed is going to sit on it until July 1st, and then they'll review it, and they'll get these new changes. There is 100% relief. There's none of this partial discharge garbage. There's also, this is new, the ability to create a group process, whether the Department of Ed starts it, or a state organization, such as your Attorney General office, or legal aid can petition the Department of Ed to do this. Basically, if there's a school in your area that's causing an issue, and you're seeing a whole bunch of these, work with legal aid or your Attorney General to work with Department of Ed and create a group process. This, because right now, without the group process, each individual student needs to prove their own case. And under the current standards, Attorney General actions and class actions do not count. You're not allowed to use that evidence. You need individual evidence. Under the group process, that will change. And so everybody who goes to that school will qualify once they show the information. Currently, there are 4 group discharges already available. ITT Tech, Corinthian, Marinello Beauty School, and Westwood, which was, I think, a photography school. If they attended anywhere through these dates, they just file their defense to repayment application and boom, their loan is going to be discharged. Woohoo! More groups are coming. I can't speculate which ones, because that would be wrong, but stay tuned. So if you're in an area where you've got one of these schools and you're seeing a bunch of students, contact the Department of Ed or your Attorney General or legal aid and see if you can get a group process started. All right. Also, very quickly, the Sweet v. Cardona case, which basically said anyone that had an application pending as of June 22nd, 2022, if their application was pending as of that date, and they went to a list of nonprofit schools, their loan is discharged, and all of those discharges, it's been approved by the judge. That just happened earlier this week, and people are already getting letters saying, congratulations, your loan is discharged. So there's a lot of good stuff going on right now with defense to repayment. If you have questions, email me. God, there's just so much stuff here. Okay, and the last one I want to talk about are changes to the closed school discharge. It used to be 120 days. You had to be attending within 120 days of school closure. As of July 1st, they extended to 6 months. Also, if any of your credits transferred, you weren't eligible for a closed school discharge because they said, oh, well, we're getting credit. They've removed that. Even if your credits transfer, you can still get a closed school discharge. And I believe the reason is because, 1, they don't normally transfer. And even if they do, you're not getting a transfer for all of them. You usually have to retake classes. So transfer of credits is not a bar to a closed school discharge. And the most important one, they are considering extenuating circumstance. So if you could explain what the hell was going on, why didn't you return to school? The example that I've seen is someone that left the school, they had an official withdrawal. Maybe they were on maternity leave, or they had to stay home with a parent to take care of them or something like that. They went to return to the school and the school was dead. The school was closed. You explain that story and they'll discharge the loan. So even though you weren't withdrawn within 180 days, because maybe it had been 2 years, they're going to connect the dots and say, yeah, we're going to discharge that loan because you never had a fair shake to finish that school. So this extenuating circumstance is massive. This is where your client gets to write their story and get rid of their loan. Okay. That's it for Fresh Start. That's it for closed school discharges and other TPD discharges. I want to open this up to any questions about student loans. And if you want to revisit other webinars, do it now, because honestly, you should be attending all 4 webinars and watching all 4 webinars to put it all together. Again, I really apologize for messing up on the attestation timing. But the DOJ guidance, I think, is the biggest thing. I think it is huge. I think it's massive. I think you have more clients eligible for it than you realize. I'm going to go back to Jeff's question about how you get paid for it. I think you're going to be filing a lot more 13s than 7s, and you can collect your fee through the 13. I also think because the DOJ guidance is so simple compared to the Bruner exam, it really is get the litigation package, do the attestation, discuss with your AUSA, get a stipulation. I think these are significantly cheaper than a regular adversary, which, by the way, I think you guys were also overpricing, but that's it. So I think they'll be significantly cheaper. I think they'll be significantly more efficient. And I think you're going to find a way that your client, if you're going to get them at a $50,000, they're going to find a way to pay you. Jill, that's a great question. Do you think we have to wait until the end of the 13, as some case law says? And I think you need to petition your judge for that, because we don't know if this guidance is going to extend into the next administration. There are some places that say you cannot file a student loan adversary before year 4 of your Chapter 13. And my response is, I understand, but because this process is so simple, I think you should do it now. You should petition the judge for it. And I think if the Department of Ed comes in and says, yes, Your Honor, we want to do this now, good, do it. Your client has to understand the most important part. If they don't finish the 13, the discharge isn't valid. They've got to understand that. If they fail to finish the 13, the stipulation for discharge is also invalid. Okay? So I think you should all be attempting to do them now. If you have a judge that says, no, I am waiting until year 4, there's nothing you can do. Steve, does the attestation consider assets? Yes, unfortunately, I didn't get to that. It considers real property. It considers vehicles. It considers business entities that they have ownership of, whether it's an LLC or a C Corp, and it considers retirement. But honestly, they're not looking for liquidation. They just want to know. Okay. Yes, Jill, you could convert to a 7. I can't talk about that. How do you get student loan payments paid through a Chapter 13 so they don't go into forbearance? Okay, that is a much bigger question, Mr. and Miss Anonymous. You have to petition the court to have an IDR plan. It's part of the plan. And if it's not part of the plan, it's automatically in a forbearance. And even though they're making plan payments, maybe not, it's still in forbearance. That's not a bad thing, though. I think my bigger question is, why do you care? If you do care because of public service loan forgiveness or IDR forgiveness, then yeah, you need to do it. What I will tell you is go to the Southern District of Florida Bankruptcy Court website, and there you can look for the student loan program, and it's all written out. That's your model. The other case to look for is in North Carolina, in Ray Buchanan. That was Ed Boltz's case. That's where all of this flowed from. Okay. So Samantha, I don't see any new protection for private student loans coming in the pipe. I just don't. There is discussion of getting rid of B. That's a bad thing, because as soon as private loans become dischargeable, they're going to go back to their old model. They're going to tie in with nonprofits, and now they'll be non-dischargeable because of AI. They're actually much more dischargeable with B because of that 221D1 IRS code. And there are ways that private loans are actually still dischargeable under B. If we lose B, we lose all of that. Okay, Parent Plus loans, everything is based on the parent. If the parent doesn't work nonprofit, then they don't get PSLF. If the student is a government worker, that doesn't mean scrap. The parent plus loan is based on the borrower. All right. So Link, you got something here. Give me a second to read through this and feel free to keep doing questions. I love this. This is great. So you've got a PhD friend who is 80. He's retired. He owes 300,000. I will help him. I do ProHack all over the place. If someone wants to volunteer to sponsor me ProHack DJ, I will come in and do the adversary. Or send him to me and I'll look at the entire thing and see if we even need to do the adversary. Or maybe we just put him on IDR because his loans are so old that he's going to get an IDR account adjustment and he'll be forgiven. Link, please send him to me. I'm happy to talk to him. Okay. And that right there, Link, that's great. Thank you for advertising that scenario. That is what Toolbox does for you. In one shot, you put in, the client gets an intake form and they fill it all out. They upload their NSLDS. They can also give you all of their private student loan information. You then do a quick analysis of it. You can see all their repayment plans. You can see what all of the IDRs would be. You then talk to your client and you're going to go through everything and say, well, it looks like you've got, I don't know, 20 years of IDR and you have graduate loans. So you still have 5 years to go. Here's what your payment would be. But I also know you're talking to me about bankruptcy. Let's see if the DOJ adversary makes sense for you, because that would be quicker than 5 years. If you're doing a Chapter 13 and you can't get them on IDR for 5 years, then you've delayed the IDR by 5 more years. So that maybe the DOJ guidance looks good. Maybe they're disabled and there's a TPD discharge. You can see all of that. And Toolbox is just a monthly subscription. So it doesn't matter how many clients you run through it. It costs you one fee per month. That's it. And that includes the documents, that includes the attestation. The attestation, I'm going to tell you, is not online yet. We're looking at a March 1st date. Partially, most of that was because the January update, we had to tweak things. And we're also, again, working with Next Chapter on that integration. So stay tuned for when that full integration is there. But Toolbox is working outside of the attestation, so you can still use it to find out what their standard payment is and to look at the evaluator and decide, you know what, it is worth looking through. If you have questions, I'm here to help you. I'm a student loan lawyer, so I can talk to you. If you want to hire me to do the adversary, great. If you want to watch how I do it and learn and then do them on your own, great. If you want me as a consultant behind the scenes, still your client, great. I am not looking to steal anyone's client. I want you guys to make money while the sun is shining. Let's make some hay. I think you're going to find lots of clients that can qualify for the DOJ guidance. We may have to do some dancing. We may have to do some consolidating before we file. Obviously, we have to decide. Look, if you need to file today because you're saving a foreclosure, okay, the loans are second share, but there's always a way to maneuver. Private loans, I didn't really talk about at all, but I have a minute since I don't see any other questions here. I love filing adversaries on private loans because they don't have any of the defenses that federal loans have. Federal loans used to lose because of IDR. Private loans don't have IDR. Their only payment plan is pay or don't pay. So it's easy to walk in and say, my client can't afford the $500 a month or the $800 a month. Boom, you're going to meet the first one. The second prong is where it becomes a little different. Do you have extenuating circumstances that will last for a term of loan? But quite honestly, I almost beat that argument. I can't really say anything yet because we're in the middle of it, but I have a feeling I rattled the industry on a private loan because I made an argument. And I will tell you this, the settlement that I ended up getting was 25%. Payable over 11 years because the industry doesn't want this decision published. So asking about my contact info, it's all here on the last slide. I'll also, I'll type it in. Actually, it's all here on the slide. jcohen@thestudentloanlawyer.com. So I love filing adversaries on private loans. Again, I'm happy to come in ProHack BJ. I don't want to warm up my welcome in states, however, which is why I encourage you to come to the workshop and learn how to do these so that you guys can make the money and get to make the main for them. I honestly, I run everything as a flat fee, even my adversaries, because I know where they're going. I've never had a trial on an adversary. Wait, let me check myself. I had one adversary trial a decade ago. Since then, I'll get settlement. I'm confident. But I do flat fee on everything. One, my client's more comfortable with the flat fee because they know they're not going to be chased. And two, you don't have to chase your client for it. I don't mind doing financing. I accept law pay. And so I can do an ACH, or I can do I can do credit card, debit cards, all of that stuff. DJ's one of my grads. He's out there in Tennessee. I see quite a few of my grads on here. I encourage you to also reach out to other local attorneys. And if they're a graduate of my course, they're going to be able to help you. If you want to know a graduate of my course, I'm happy to point you to someone more local. I do actually get quite a few family members that pay the bill, benefactors. They are happy to pay my fee to get their relative out of the loan. I have quite a few children that will pay me for their parents' total and permanent disability discharge. And I have quite a few grandparents that will pay for the adversaries. So believe me, they're more than happy to pay your fee when you show them what you can do. And private loan adversaries, you're not going to get a full discharge. You're going to get them an excellent settlement. From my experience, I don't have deadbeats. I have people that want a fair shake. If they had a fair payment that pays off the loan, they're happy to, because they come in feeling this moral obligation. It's not a legal obligation, it's a moral obligation. I want to pay something on my loan. All right, then my adversary is going to get them. I talk about all of this in my workshop. It's a 2-day workshop. Again, there's CLE credit in most states. I think we have to update that chart on the website. If you want to know more about the workshop, studentloantoolbox.com. If you want to know about the software, studentloantoolbox.net. If you want to find out more about Next Chapter, again, nextchapterlegal.com, bankruptcy, keep those questions coming and reach out to me via email. I'm happy to help you folks out. It's not uncommon for some of you to become clients. I'm okay with that. I don't tell people who my clients are. I also encourage you, if you want to be a client, to see how the process works. Fine, go to my website, do the intake form, and you get to see how I work it. You also get to see how the software works from the client side. So there it is. Really excited for the integration coming up with Next Chapter. And I know we're moving forward now as fast as we can.
All right, sounds good. I don't see, oh, there's another question. So I'll let you have that.
Okay. The client paid off their Parent Plus loan. The payment was sent to the wrong place, but they kept the payment and are not showing the payment as paid off. Samantha, that's a different issue. I mean, I'd want to know where the money went, number one, and you could pull up the student aid report and find out where the money's supposed to go and find out what's going on there. Fresh Start is only if they're in default, but they still need to get on a payment plan. Feel free to email me on that and we can talk a little bit more detail about it. That's a one-off. That's a law school bar question. It's the exception to the exception to the exception. So go ahead, Mandy.
All right, well, thank you so much, Josh, and a big thank you to Student Loan Toolbox and to the Next Chapter team that's been here moderating and helping out. Thank you to everyone who's joined us. We're really looking forward to this partnership and integration. So I hope everyone found all of the tools and resources that we provided helpful. We're getting a lot of requests for the presentation. So that's a huge sign that this is all very, very, very helpful, practical tools for everyone. So we're going to be sending out that email here by the end of the day with copies of these. It's going to include these resources, everything you saw in the presentations, and links to the recordings as well. So, and again, if you have more questions, the emails are going to be available for Josh on here, and we have the next chapter contact information as well. So we are happy to help. Thank you all for joining, and I hope you'll also register for BK Week so we can continue with this great content and learning around bankruptcy and topics like student loans. So thank you again, everyone. I hope you all have a good rest of your week.